Илэрхийлтийн үеийн уушиг хэлцээсэн сайдын зөвлөлийн бичиг маш баярлалаа. За одоо бид үндсэн бодлогын үйл ажиллагаа руу орж байна. За манай хамгийн ихний илтгэлийг одоо аудиентик арт үйлдэлтэй эмзэг бүлгийн мод зөрчлийн эрхийг хамгаалахад материалын үндэслэх үүрэг гэдэг сэдвээр холбооны гэрэн улсын холбооны материалын техникийн дэвшилт хэрэгжиж олон улсын материалын холбооны өдөртөх зөвлөлийн гишүүн тус холбооны хамтын ажиллагааны комиссийн дэвшилт хэрэгжиж Ноён Бог Рихард Бог хэлэлцээд байна.
Dear Presidents, dear members of the Quorum, ladies and gentlemen, dear colleagues and friends, the notary's role with regard to protecting disabled persons, minors, elderly persons, whom I will refer to in the course of my speech as vulnerable persons, has been a popular topic at the UNL for quite some time now. The organizers of this morning's event have allowed me to put the matter of material work concerning vulnerable persons into a wider context. In most of the material codes of the UNL member states, there is a regulation according to which notaries are duty-bound to protect inexperienced or inexpert parties from disadvantages. That is, as it were, the general clause protecting vulnerable persons is only one aspect of this. I would like to take this opportunity today to outline the official duties of German notary where vulnerable persons are involved. There are cases which occur from time to time in our work, but I cannot say frequently. I will then take the liberty of considering further aspects of this wide-ranging subject, namely those which are part of our day-to-day business. The center around the general official duties to protect the weaker party and in particular the compliance with the regulations governing consumer protection. The simplest are the regulations which the notary has to follow when it concerns the participation of physically disabled persons, which means persons who cannot see, hear, speak, write. Different regulations have been established for such situations in the various countries. For example, the participation of witnesses, another notary, etc. Such additional requirements are dispositive in Germany, that is to say, they are optional for the person concerned. The matter becomes more difficult if the notary has reasons to doubt the legal competence or contractual capacity of a party. In such a case, the notary has to ask the person concerned to present a medical certificate issued on the day of the notarization. According to the ruling of the German Federal Court, Federal Supreme Court, a medical certificate from simply any doctor is not sufficient. In such cases, it must instead be issued by a neurologist. If the doctor is unable to testify the legal competence beyond any doubt, the notary has a problem because legal competence can no longer be established ex officio by the authority in Germany by virtue of one's official position. If a person is no longer able to arrange its legal affairs, he or the family members can ask the court to appoint a carer for this position. The carer signs the legal document instead of the person But this does not make it valid yet, for in all these cases the court's approval is still needed. If, for example, a person under care sells a property, the document will not become effective until the court has approved the sale. The process for obtaining approval of the court is lengthy. Such processes also cost money. It was with this in mind that the Federal Chamber of German Notaries started to propagate the idea of setting up special powers of attorney, so-called precautionary powers of attorney. Precautionary power of attorney needs mostly at least certification of the grantor's signature. It gives the person or persons named to either one, granting the power of attorney the right to represent the grantor in the event of there being doubts as to his legal competence. Such precautionary powers of attorney are all entered in a special and electronic register at the Federal Chamber. In addition to the notaries, all the courts have access to this register too, and it can therefore be verified in any particular case if such a power of attorney actually exists. To date, 3.5 million of such powers of attorney have been entered in this register. It is it's a real success story. Notarizing precautionary powers of attorney is fortunately only a marginal part of our work. Our wide-ranging competencies focus mainly on real estate law, company law, the law of inheritance, and family law. Under our Notarization Act, we are obliged to make sure in all authentications that any inexperienced and inexperienced the parties are not disadvantaged. The law does not say anything else on this matter. Nevertheless, this requirement standardized primary duty of the notaries, and not complying with it constitutes a breach of official duty and may lead to claims for damages against the notary. There has been a substantial number of court rulings over the years concerning this issue. I would like to give you two examples. According to our civil law code, it is possible for couples to enter into a marriage contract before or during their marriage, in which the legal consequences are regulated should they ever get divorced. Such a contract typically deals with rights to the adjustment of assets unequally divided, post-nuptial maintenance, and participation in the mutual rights to draw a state pension. It is not forbidden under this law to completely exclude these rights in the event of the couple getting divorced. Nevertheless, the German Supreme Court has ruled that excluding such rights is invalid if the weaker party, which is usually the wife, is unreasonably disadvantaged by this. If the couple's arrangement is that the wife should not go out to work, but should instead look after the children, such a marriage contract would be completely, partially invalid in the event of divorce if the wife did not manage to enter into gainful employment. This applies in particular if the circumstances at the time the contract was signed suggest that the disadvantaged spouse was under certain pressure. In the past few years, we have seen a relatively large number of migrants coming to Europe from the Middle East and from Africa. Some of these migrants have married German citizens, perhaps motivated by the right of residence, which they would then enjoy. Marriage contracts, which in the event of divorce provide for a restriction for the foreign spouse, may then be invalid because they were concluded against the background of imminent eviction. This is also true for the relatively frequent case where a marriage contract is concluded at a time when the wife-to-be is pregnant. The standard question each and every notary asks engaged couples wanting to conclude a marriage contract is whether they are already expecting a child. If they are, then he sends them home again and waits until they are married before proceeding with the notarization.